I'm just requesting the
Sir,
controller.
you can.
It's like a sunny day in Durham.
Good evening, Sujjain.
Good evening, Manas.
All right, while people are still joining, I will set the context. And before we get going, we are broadcasting it. In addition to this link, we are broadcasting this session on our YouTube channel also. So there are additional questions which may come in from there. I will present in the brief window we have towards the end. To everyone in this session, we have three eminent speakers speaking about the punishments. Basically, the question we are seeking to achieve is that in current times when more and more production and delivery of goods and services and number of and the impact of corporate action on the welfare of population at large is too disproportionate now. Given that, how do you bring in corporate discipline? That's a central question. If all of you are, if you are all of you are noticing the debate around equitable distribution of the COVID vaccine, you see that how important is the corporate action to address the corona problem, right? And the distribution of the vaccine. Similarly, in almost every walk of life, the corporate action is very critical. Markets are the predominant vehicle to deliver what we consider as the running of the economy, production of goods and services. So therefore, functioning of the markets is very critical when it comes to macroeconomic context. And in that context is situated the crimes we see around and how they erode the credibility or the welfare quotient of the economy. So therefore, to discuss that, we have today Professor Thom Brooks, who has written a book titled as Punishment: A Critical Introduction. This is his second edition, which is expanded. He serves as the Dean of the Durham Law School. I will set the context of the book also. Punishment, A Critical Introduction, deals with the philosophy of punishment. This offers a new and refreshing approach that benefits all kinds of readers, whether you are working in a government department or you are a researcher or a practicing lawyer. It has something to offer to you. It is, I can say with some amount of confidence, the first comprehensive critical guide to examine leading contemporary theories of punishment. The book explores, among others, retribution, the communicative theory of punishment, restorative justice, and the unified theory of punishment. I know to some of you it may sound very academic. That is why we have two practicing legal minds here. But first, welcome Tom to this session. Thank you very much for joining us this afternoon. Along with to discuss these issues, I have great pleasure in welcoming my friend Manas Chaudhuri, who has spent time in judiciary in West Bengal in India, as a government officer in Government of India, and as a law enforcement official at MRTPC and the Competition Commission before he moved to the practice. And currently he serves as a partner in Khaitan Company. And I can say that he's one of the best minds to discuss law and practice of competition issues in our country. The second discussant, Mr. Sujjain Talwar, an eminent person in the area of infrastructure and hospitality services. He's a co-founder, partner at the Economic Laws Practice. I have had good fortune of working with him. And all of you know that what kind of trust his name generates amongst the people who deal with infrastructure law. His work includes infrastructure projects in Yemen, Fujairah, Djibouti, Maldives, and a number of other countries. Sujjain serves as an independent director on many boards, and being an infra man, friends call him rock solid. So welcome everybody. While we begin the session, let me invite Professor Thom Brooks to present the idea of his book and how he has dealt with the whole theory of punishment, particularly from today, as you know, we are dealing with white collar offenses, maybe another day other kinds of offenses, but let's begin the white collar offenses. Over to you, Tom.
Wow. Thank you so much. I hope everyone can hear me okay. I am
yes.
Very pleased to be here. I'm enormously honored to have any discussion with anybody about my thoughts, whether they be in private or public, and with such an eminent chair and terrific eminent commentators. I couldn't ask for more. So I'm very pleased, and I'm looking forward to probably learning rather than defending myself from colleagues in India. I want to say that I very much, before I even talk about my book, I very much wish I could have been present with everyone. I do like to physically be there and meet people, and of course circumstances don't allow that. And I hope everyone is safe and well. Everywhere is looking precarious, but I very much hope and feature that such circumstances would allow us to come together, and I would be committed to doing that if I can. Now turning to the book, I'll just say something about why I wrote it, and something about the general framework, and then become educated, as everyone else will, about how far I hit or miss different topics or targets later on. When I first came to think about the philosophy of punishment, as someone trained in philosophy, I am not trained in commercial law, corporate law. I do not sit as a judge anywhere, and I worry that might show too much in what I had to say about those topics. But I came to it from the philosophy perspective, and a deep disappointment in much of what I read in the area. One, that the general books covering a broad spectrum of theories all seem to be pretty much out of date. There wasn't much that was published recently on the topic. When I first wrote the original edition in 2012, I was very disappointed there wasn't much out there, and that most of what you could find on your bookshelves relating to theories of punishment, whether they be Eastern or Western or something else, a lot that I had come across in my search were kind of about particular views of punishment, and saying only about kind of one particular theory, and not really relating it to the rest of the literature, how it fits into something wider. And I found that the philosophers would often say you had to choose one view of punishment from an existing menu, or how, you could, you have to be retribution or deterrence or rehabilitation or something else. You had to choose your theory. You had to fight the others off. And that one theory, to win the battle, so to speak, you had to show that it applied to everything better than everything else applied to everywhere, whether it be white collar crime or whether it applied to something else. If you could argue that your theory didn't apply to white collar crime, but could apply to something else, then that was kind of a big problem for your theory, and we had to go somewhere else. So I was concerned about this, which seemed to me kind of almost ideological, kind of, trying to get punishment in kind of a one-size-fits-all, very narrow views of theory that weren't very broad, didn't seem to be as aware as I think they should be about what the broader context is. I did not like different theories of punishment all thinking that they had to fight off each other and thinking about how they could come together was somehow not an option or something we shouldn't consider. And then there's a further issue I want to flag, which relates to the topic, that when I would read about philosophy of punishment and how it applies, you typically had only 1, 2, or 3 cases. So every article, every book about theories of punishment will talk about the treatment of murder, what to do with murderers. And there's also something about theft that might relate or not, depending on your view, to right now. And very rarely, I mean, sometimes, a minority of work would touch on things like sexual crimes, typically only mentioning rape. And what concerned me about this was several things that I wanted to correct. The philosophers didn't seem to be connecting to many of the crimes that people actually do. Most people here in the United Kingdom are not murdering and are not at least convicted of theft, even if they are stealing. Most people are in trouble with the police, are in trouble with convictions over traffic offenses and drug-related offenses. And yet these are often not referred at all or on the radar for thinking about theories of punishment. I think that was a mistake. And I also think it was a mistake that the crimes that actually do happen to people in broad measure, and violent things that happen to people in broad measure, things like domestic violence, however one wants to define it, was missing. The importance of juvenile offending, and should people under the age of 18 or 21, or pick your favorite age, should younger people be treated differently than older people or not? And in most, if not all jurisdictions, you have some distinction being made where different theories of punishment are thought to apply. Was that correct? Was it incorrect? How does that work? Where's the kids? And after all, teenage boys are often the ones that are doing most of the crimes that people are writing about anyway, of whatever, whether they're counted as children under the age of adult consent or tried as adults or not. So I thought that these are kind of some broad issues that I wanted to touch on. A comprehensive book that looked at the full range of major theories of punishment that I was aware of. I'm happy to be called out if there's some more I should do. My publisher, I'm sure, would be happy with a 3rd edition if I should add new theories. I'm open-minded about that. So these were, I think, the main views out there that I look at. I group them as those who have basically a single kind of general purpose: retribution, deterrence, rehabilitation, restorative justice. I then look at what I call kind of mixed approaches, mixed theories of punishment. One classified in different ways, but one broadly of Rawls, by John Rawls and Herbert Hart. Some might call it a negative retribution. We can call it other things if we want to go there. I then look at the communicative theory and expressivist theories of punishment, which can claim to be bringing different considerations of, say, retribution, deterrence, and other rehabilitation in together in a particular way. I have real doubts about that. And throughout each of these different theories of punishment that I look at, one thing that I want to note for each of them is that people support the views for good reason. So for example, a virtual show of hands, and I do not want my commentators to raise their hands to these questions. They're mainly rhetorical, but I want everyone watching this or listening to this to raise your hand. If you agree with the following: who thinks we should punish people who did not do what we accuse them of doing? I can see into virtual internet land, and no one's raising their hand, right? Wherever we think objectively they could be, that we should do something. We should try to reform, rehabilitate, if possible. Who's against that? And I think very few are against doing help. Where you get the disagreement between the different views is on a balance. So, if the answer is whether we give someone what they deserve versus, if that were to somehow to stop us trying to rehabilitate someone before release or sending some messages out. And there's a question here. First of all, is, philosophers often think we need to choose which of these is better than the other. I think one question to ask ourselves is, are these good reasons in the first place? And if the answer is yes, then to turn to the question of, is it possible to try to bring these together somehow and try to have some, I call unified view, but some kind of mixed view. And part of my motivation here is that in almost, I'm saying almost, I'm not saying almost every article or book that I've ever read on the philosophy of punishment, almost none of them make any reference to actual sentencing guidelines. And I'm referring not only to people writing in philosophy departments, I'm also writing about legal philosophers writing about punishment who work in law schools as well. I'm not trying to have fighting words with anybody, but I almost never see it. And I'm speaking specifically, what particularly exercised me as someone who's an American and British, from the United States, living in the UK, citizen of both, is that in the two countries that I have a passport for, both of them have sentencing guidelines. One, England and Wales, that was broadly incorporating elements of the Model Penal Code of the United States. That's not controversial. It seems not controversial in the UK. And a model from the Model Penal Code in the US that has been adopted or has had an influence on jurisdictions on many countries around the world. In that Model Penal Code, as practiced in various states in the United States, as well as England and Wales, as being developed in Scotland right now, and their sentencing commission that's underway at the moment, and in other countries that have sentencing guidelines, what you see is more than one purpose for sentencing as justifying by law someone being sentenced for a crime, and that, according to the guidelines, that there is no kind of philosophical concern about whether we can punish someone with regard to they deserve it, with regard to trying to deter others, with regard to trying to enable the rehabilitation of the offender, with regard to potential reparations to victims, so on and so forth. And left then broadly to judges within various constraints on discretion that differ from one jurisdiction to the other about how that judge or magistrate can then impose a sentence on someone with reference, if they want to state that, to one or more of these purposes. So to sum up some of the broad framework I'm talking about, on the one hand, you have philosophers who are saying we must choose between one or another purpose, and there can't be multiple purposes. Often they're often concerned about these purposes being clashing and just not being able to apply it, with very limited exceptions like Rawls and Hart and a few others which I discuss. On the other hand, we have the judges in the United States and across the United Kingdom and elsewhere that are using, on the bench in real life, who are actually punishing people, actually making decisions under the law. So it's supported by democratically elected governments in those jurisdictions that are deciding this with reference to multiple purposes of sentencing that don't see this clash. So either the philosophers are right, we need to choose amongst things, and so therefore these guidelines, they seem to not know what they are. These guidelines are deeply problematic and they need to be fundamentally rewritten. Or on the other hand, these guidelines that our judges and magistrates in the jurisdictions I've been a citizen of the guidelines seem to be doing something probably right. The problem is that they lack some kind of theoretical coherence to why these purposes and not other purposes, and how they might fit together. So to summarize, mostly, I'll stop in a moment. I was given, I think, only 15 minutes by Navneet, and I don't want to be in trouble with anyone on the panel, certainly not in the format. So on the one hand, I'm looking at these different theories of punishment, trying to take each seriously, saying that there's a reason why people do think there is something important about each of these theories of punishment. At the same time, raising serious concerns about each, and trying to come up with some reasons against each that others, I think, have missed, taking a very broad view of the literature. For example, retribution, the idea that people should be guilty before being punished, if nothing else, is something I think is very justifiable from a number of perspectives. At the same time, so what does it mean to deserve? Is this a question of whether or not someone has done something evil or not, and how do I know that? And is what makes crime evil? And if so, then what am I supposed to do with traffic offenses? What am I supposed to do with a variety of other things that are a lot of the crimes that people will want to have punished, that a theory of retribution might have real trouble with, if it's really some theory about moral good and moral bad, and then presupposing a particular view of what a moral good and moral bad is in societies that often have some plurality or not as clear a view on that issue. So that's kind of one thing, and I raised some things about others. Read the book for more. I'm happy to take questions and say more about the other things too. So we're just kind of going through each of these things. Why do people find this persuasive? Some reasons why why there's something good about retribution or deterrence, rehabilitation. Why the theory, as presented by its adherents, isn't watertight, isn't 100%, does have some serious issues to question. Looking to some mixed theories that have been presented, finding flaws with how they cohere, arguing, as I do, that they don't actually bring together multiple purposes as they say they do, like the communicative theory doesn't, as I argue, some issues with Rawls and Hart, and then offering my own way of trying to have a framework for thinking about how we might bring different purposes together from these different theories and kind of have our cake and eat it, as it were, kind of approach there. And then I turn to, and this is where I'll stop, I turn to a number of case studies, because again, most of the philosophers of punishment that I've read, it's broadly theoretical, with a few cases sprinkled about, some instances of someone murdering someone, or what if someone steals from you, and not much more than that, and with usually no reference at all to any particular laws, certainly not from more than just one jurisdiction, and certainly also no kind of discussion, awareness, it would seem, to how this is practiced, and some of the criminal justice work going on, as it were, in the background. Do these punishments work in these areas? What are the facts about these case studies that they are applying their theories of punishment to? So what I wanted to do is I use a broad range of case studies, looking one at the use of capital punishment. I look at juvenile offending, and should juveniles be punished differently than adults? If so, then why? Should it be different? If so, then why? I look at domestic violence. I look at a number of sex crimes, including rape and child sex offenses. I think I mentioned domestic violence already. And then I added for this book more chapters, completely rewrote my unified theory, and then added on social media offenses, crimes that happen online. It's a more prevalent thing that I also don't see philosophers of punishment talking about. And finally, corporate crimes as well. And kind of thinking about groups and the punishment of groups is something that you'll also find missing in about everything that I've seen in the philosophy of punishment. So then trying to kind of show that what these case studies are, trying to give some kind of sense of what these things are. Usually in the literature, you have very different theories of punishment put forward as the way to do it. So for example, death penalty very heavy on retribution or deterrence. Juvenile offending, very heavy on rehabilitation. Domestic violence, something that isn't really talked about, but then a split. Some interesting work on restorative justice in there. And then trying to show that one raising the question of these different case studies, a lot of people seem to talk about different theories of punishment being relevant, maybe for different cases. And then that raises real issues about, what do I do if I have my theory? How do I apply it? And I try to show how a more pluralistic conception is plausible and more applicable to things. I think I've spoken longer than I should have, so I'm going to stop right now so I'm not in trouble with anybody. Well, any more trouble than I'm already in. So thank you very much for your attention, and I look forward to hearing what people have to say and learning from it. Thank you.
Thank you, Thom. That's, I think, a very good academic context of theoretical context of punishments. Let me bring the two practitioners in so that we can understand. In addition to whatever Manas is going to speak, I will make a special request to him to demonstrate that how when a company or an individual is found breaching competition, any provision of the competition the first time vis-a-vis a repeat offender, a big company vis-a-vis a small small or micro enterprise. How could the theories of punishment be looked at in a reasonable manner, in a unified manner, when it comes to competition-related offenses? Over to you, Manas.
Thank you, Navneet. Wonderful, really opening statement from Professor Brooks. In fact, it has helped me a lot. And I would just be limiting myself to the Competition Act, which is, of course, a very interesting feature. And obviously, most of the criminal offenses which have been spoken about until now would not be really applicable to Indian competition law because it's a civil legislation. So we will have to confine ourselves within even for the offenses like bid rigging and cartel, our law is civil offense. So it's definitely very different from what we generally understand from criminal jurisprudence. That element of mens rea and actus reus is definitely missing in the Competition Act. But at the same time, it's very interesting to share with you. I in fact had gone through your chapter 13, and that is actually very interesting for me to share my experience with my last 11, 12 years of private practice into the antitrust space. So there are 4 elements which you have brought out, which is very conveniently suitable for my short presentation of about 8-9 minutes. The 4 elements which you have included in chapter 13 of your book, I read out one after another. The company's members have shared goals. That is very important. The members of the company, that means since company is a juridical person, it is not a natural person. Obviously, the members of the company must have a shared goal to commit an offense. Number 2, members contribute to advancing the goal. Absolutely suitable to a competition breach. Number 3, company makes decisions to advance the goal. And the 4th, the members have common awareness of that goal, which means that before committing that breach, they were aware that what they are going to do may be punishable under the law. So with the knowledge of having and penal consequence is clearly already imbibed in the Indian Competition Act. Only the problem is because there is a provision of individual liabilities for a company's breach of a Competition Act. So whenever I'm talking about breach of Competition Act, I'm speaking strictly with regard to the breach of cartels, bid rigging, resale price maintenance, refusal to deal, exclusivity, tie-in, and abuse of dominance. These are the 5-6 areas which are commonly known all over the world in the antitrust space. And these offenses invariably have been found to have been committed by companies with a conduct. Either it is an unilateral conduct in case of an abuse of dominance, or it is a collusive conduct in case of a cartel or a bid rigging. So this is a very cast in stone kind of a situation where the authority who has to apply that principle within the confines of the municipal laws in which the competition agency is working, but at the same time, it has got a huge ramification in international cross-border issues because Competition Act, though it's a national legislation, yet it has got that concept of cross-border trade, which is affecting the markets in the country of domestic origin, and where the competition authority is sitting to rectify the market failure if there is any. So then the principle becomes very interesting. So if suppose I'll just give you an example, the leniency regime, which is known as any company trying to voluntarily blow whistle of a cartel against his co-cartel members, it is a criminal offense in the US, it's a criminal offense in many jurisdictions. Now, if that US company or any company which is having a criminal jurisdiction in the country of origin indulges into a similar breach in India, then the Indian Competition Act would be only relatable to a civil offense. It would definitely not be trying to make that as a criminal offense because the country of origin had criminal offense. And that clearly makes a very interesting departure. Say, for example, if there is a criminal individual liability in a case of a cartel between US and UK, I think the policy of extradition would be very easy because both the countries have criminal offenses in respect of cartel. But if it is an India versus United States, the extradition of that individual would come in the way of the legislation being civil and other legislation being criminal. So there are certain limitations, but the intent of the Indian Competition Act is almost identical to the international best practices. As Navneet had asked a very interesting question, that if at all a repeat offense happens, the mechanism in the Competition Act clearly directs the company who has committed the breach for the first time, they must adopt an internal compliance mechanism, which should be not a sham compliance, it must be a robust compliance, where they can always justify whenever there is an alleged breach, they should be able to justify as to why were they indulging into that kind of an alleged anti-competitive practice. If they are able to satisfy the authority by their economic and commercial justifications through the mechanism of the competition compliance program of the company, perhaps their subsequent offense may be mitigated. I would not say that they would be exonerated, but it can be mitigated depending on the facts and the circumstances of the cases. But at the same time, how would one measure the reputational loss caused to the promoters, reputational loss caused to the CEOs, CFOs? These are some of the areas which I think a competition compliance may help them to mitigate to the extent they are able to do it. So it's a Competition Act is not a pure white collar crime as we know in India. It's kind of a specialized white collar crime because we have got a different regime for white collar crime in India. And we also have some amendment in the Companies Act in 2013, where for the first time, the Indian Companies Act has tried to define corporate fraud. And the definition is so far and wide, if one wants to really interpret it in a manner to bring within the ambit of corporate fraud under the new Companies Act and bring it within the ambit of the Indian Competition Act, one may have the ability to do that. I am not saying that they will invariably be successful, but what I am saying is that there is a possibility of an enabling link or a causal link between one of the provisions of the Companies Act 2013 with one of the provisions of the Companies Act. And insofar as the individual liabilities of a senior functionaries of a company is concerned, read with the corporate fraud, there can be a possible causal link between the two. I am not saying it has so far been decided, but what I am saying as a student of law, that we can really find a causal link between the two. Why would Government of India and Parliament in 2013 bring in a definition of a corporate fraud from the old Companies Act of 1956, which did not have? So with the markets having changed drastically between 1956 and 2013, the Parliament thought that it is time that we should define corporate fraud. And when they defined corporate fraud and brought in amendment to the Indian Companies Act, they created a schedule, a special schedule, in which they said an individual penalized of a fine in a company of a rupees 1,000 and above, and if it is a company's individual, then can be tried under the Competition Act as well as Companies Act. Now the question arose, does it mean that any penalty in excess of rupees 1,000 against an individual under Competition Act comes directly within the ambit and scope of the Companies Act? The answer is debatable, because the courts have defined the difference between fine and penalty. Fine is typically a breach which an individual has committed on an order against a court, non-compliance of a court order. Whereas penalty is something which the courts have defined that in the course of your business, you should have followed X principles, you have not followed X principles, hence you are liable to be penalized. Penalty is not a fine. Now, the Companies Act had said that an individual who is fined is liable also under Companies Act. Indian Competition Act has actually made most of the provisions as penalties. Only few sections of the Competition Act talks about fines, and those are only where the companies or the individuals have not complied with the directions of the commission or the authority, and in the process they have violated a direction which has already been given against them. So these finer distinctions are generally interpreted by all of us before the court. We try to justify, because this is the way the law has been evolved. And I'll tell you very interesting, the annual report of the commission, that is the CCI, which is placed every year before the parliament. It's a publicly available document which is in the website of the CCI. The annual report, which is the latest one, 2019-2020, it has talked about that in the last 3 financial years, the total penalty imposed by the CCI against the companies is to the tune of USD 1.7 billion, against which it is only 0.3 million which has been recovered. Now, you may say that CCI has failed, but I would never say that, because the course of appeal is available to the party aggrieved. And now if a person goes into the court of appeal and on merit the court of appeal thinks that there is a merit in hearing the matter on merit, then it would stay first and foremost thing the penalty imposed by the CCI. If it does not impose a stay against the penalty, then the whole appeal becomes infructuous. Because if that individual has to pay the penalty and also proceeds with the appeal, it doesn't make sense. So in order to make a balance between the logical conclusion of an appeal with the CCI's order, generally most of the penalties are stayed. So it would never mean that CCI has not been able to impose the penalty correctly, because the appellate tribunal on the threshold at the time of admission of the appeal never says that the penalty is too high. Because I can just quote you one example. In the cement cartel case against 10 cement companies, the CCI imposed a penalty to the tune of about 1.6 billion US dollars against 10 cement companies. And in the Court of Appeal, it has been confirmed by Court of Appeal. That means Court of Appeal had confirmed 1.6 billion US dollar as the correct fine, besides agreeing with the findings of the CCI with regard to cartel. Now, all the cement companies have gone to the Supreme Court, because that is the final Court of Appeal. It is pending. It does not mean that the pendency of the appeal before Supreme Court has nullified the total computation of penalty by the CCI. So in such circumstances, since appeal is a process and it's the law which is based on principle of natural justice and rule of law, parties agreed by any order of the CCI has a right to appeal. And in appeal, unless the penalty is stayed, the appeal becomes infructuous. So I would never paint that CCI's ability to impose penalty has not been met is incorrect. It has been in the process, and as and when the final order comes from the Supreme Court, we would come to know as to how much is the reprimandation by the courts against the individual companies. So right. I just would like to conclude by saying that it's a very specialized kind of a white collar. It is not in real sense of a white collar, which is a separate regime in India. But Competition Act, since looks after only the corporate and the individuals, it is definitely a kind of a white collar crime. One point, I have again taken it from your book, Professor Thom, that there is a vicarious liability with regard to an individual committing an offense for which the company has been held liable. That is very much part of the Negotiable Instrument Act in India. And whenever there is a dishonoring of a check, the vicarious liability is always imposed upon the company, not against the individual only. However, that particular law is a criminal law, whereas the Competition Act is a civil legislation. Though the Section 141 of the Negotiable Instrument Act and Section 48 of the Competition Act are mirror images of each other, but we have to see how the jurisprudence evolved, because in case of a Negotiable Instrument Act, a person who is issuing a check, he is supposed to know whether or not he has got the appropriate credit in his bank. If he does not know that, and if he says, I don't know how much balance I have in my savings bank's account, he is actually telling a lie. On the contrary, in case of a Competition Act breach, if suppose the promoter is sitting in the city of Mumbai and he has got 30,000 people working in the field, and one of such persons has committed some breach which is a competition law breach, the promoter really should not be held liable for that as a vicarious liability, because it is remotely connected. So I stop here. It's a mix of criminal jurisprudence, not truly a criminal law. No sanction of crime against directors, etc., is possible, unlike in the US, where in a cartel offense, the directors can be sent to jail. It is not possible in India. It's only a civil penalty, both for individuals as well as for the company. And as you rightly said in your chapter 13, that actually is the crux of the Indian Competition Act insofar as corporate breaches are concerned and how they are being sanctioned and remedied. Thank you very much.
Thank you very much for your passionate presentation on the Indian competition law and how it relates with the companies and the individuals. Let me now request Sujjain Talwar to bring in his dealings with the span of white collar crimes is much wider. I think he's going to put us in touch with a variety of white collar offenses which we can gauge as to how effectively the Indian laws are able to deal with them and what could be the possible directions going forward. Over to you, Sujjain.
Thank you, Navneet. Thank you, Manas. And thank you, Professor, for the very wide-ranging topics that you've covered in your book. I have to be honest, I haven't read it. I have just glanced over it. But within the limited time that I have, I thought I'd just present you with what we as practitioners see as white-collar crimes. And while there is no Indian definition for a white-collar crime, I think widely it is regarded as crimes committed by someone who works in an office or who works in a company, as opposed to the thief or the burglar who usually gets caught and gets sentenced very easily. So if we just move the slides, Sushita, from there. We have a very famous cartoonist whom all of us have grown up with in the times of India, R.K. Lakshman. And you could pick any of his books and they always cover bribes, crimes, political situations. And it took us just 2 minutes to pick up the heart of the problem, as he seems to have gathered from this very cartoon, that everyone seems to be in hand in glove. And that may be one of the reasons why you find that those who are actually put in jail or who are actually convicted of a white-collar crime are very far and few. And this does not isolate itself only to India, but as I've seen, it cuts across continents. And one of the questions, in fact, I had for you, Professor, was in your experience when you did write the book and did your research, do you find that, you find white-collar crime more in countries which are of a capitalist inclination, or is it widespread even in others? So, if you could move on. Yeah. So these are the very few white-collar criminals, if I could call them that have been convicted or in the process of being convicted, but have certainly found themselves behind bars, even though the trials may not yet be completely over. And a lot of Indian company law and Companies Act and the markets and market regulators have come alive largely because of 3 or 4 cases that occurred in the last couple of decades, which have caused wide-scale changes to the penalties, offenses, and the regulators in how they treat uh, corporate offenses. The famous case was in the IT industry of Satyam. Then there was someone in the hotels, hospitality, and airline space, Sahara. Uh, and more recently were people like Vijaybhoomi and Modi, both of whom I believe are uh, at Her Majesty's guests in your country. We can move this slide further, Suchita. So as you can see, India doesn't have any fantastic rating when it comes to Transparency International. Out of 180, we are 86 in terms of our rating. We hardly moved 8 spaces. Sometimes we get, government gets very excited if we move up or down by even a few spaces. But if we claim to be a superpower, if we claim to be the type of market that we want people to invest in, then certainly these numbers are very important. Move to the next slide, Suchita. So where does white collar crime manifest itself, at least in the Indian context? We find largely, as Manas made and alluded to, was corporate fraud under the Companies Act. We have historically had very high tax rates, sometimes as high as 80+%, though they are down to more realistic numbers now. So therefore, one avenue of white collar crime has always been tax evasion. In the sector that I deal with, largely infrastructure, we come across cases where the government is always on the opposite side. And so you will have issues under the Prevention of Corruption Act. Money laundering, again, is very common. Largely insider trading, hardly any convictions. Some people take it as, in fact, not being a crime. But nevertheless, under the securities markets, that is largely being enforced through a penalty rather than conviction. India has very strong exchange control laws, and therefore what can go out or what can be received and in foreign exchange are very strictly regulated. They are more relaxed now than they were in the past. But again, that is seen as an area when breached amounts to a white collar crime. And lastly, an area where there is very strict controls and almost a deeming fiction that if you breached it, you are a criminal, is in food laws, food and safety standards. If we could move quickly, Suchita. So what are the factors, honestly, that from an Indian perspective drive white collar crime? Of course, the first thing is that a lot of it is corporate, and now the desire is to provide your shareholders better profits, better outlooks within 3 months, and because we have 4 board meetings a year, so it's the short-term outlook, and therefore the pressure to try and show better profits or revenues, low prosecution. That is a very sad fact, but when it comes to somebody stealing, he or she is prosecuted quite easily. But when it comes to stealing in the true sense in a company concept, that moral indignation does not seem to be there. And as a result of which, we find very low levels of prosecution. Somehow people feel it's white collar is almost like there is no victim. No one is being raped. No one is being stolen from as such, and you can't see the victim, and therefore it's a victimless crime. Largely, the factors again continue to be lack of internal controls. So, in order to overcome all of these, you find, Suchita, if you could move quickly. Please move from this also. We don't have that much time to discuss. Please. As I was saying, the lack of prosecution, what people normally say is you may not you can do something as a white collar crime. It may not be discovered, it may not be investigated, there may be insufficient evidence. You may still have further action. You may, leave the company, not be caught, no criminal prosecution. So there are ample avenues available for you, which actually sometimes jokingly makes fraud and attractive as an option. So if you could just move from here, Suchita, you could move through a little bit faster because we don't have that much time. But one thing that I think Manas also brought to your notice was that the use of the Indian Penal Code is quite widespread in lots of parts of a company, whether it is just even measurement or it is in in cyber. But people are very quick to use the Indian Penal Code, and offences like cheating, conspiracy to cheat, etc., breach of trust, are very widely and easily used in India. Then, Sujita, as I said, India's approach at the moment is a balance, because while we would like to see some people behind bars for what they have done, big industrialists, etc., people also realize that prosecuting can take years. And therefore, under the New Companies Act, I think there has been some pragmatism and some principles have been let go, as a result of which people have decriminalized. The parliament has decriminalized a number of offences, but has increased the amount to be paid by way of a fine, as a result of which it goes to show you what the mood of parliament is just now. Let business move on. We are willing to forego the criminality so long as someone can make up by way of substantial fines. I'll just stop here because I know I've gone well above my time, but we'll leave it for discussions. Thank you.
I think you have left at a very, very critical question, Sujjain, that, almost all the governments across the globe, they're attracting FDI, they're attracting investments. They want to promote corporations. They want to paint a picture that here is a country which is investor friendly and so on. So therefore, a number of countries actually now try to see that what bucket of crimes should go to really criminal side and what should go to the civil side, wherein you can get away with just a penalty. And I think Companies Act is a brilliant example where more and more, in fact, it's a work in progress, even though it was passed in 2013, but I think it's still a work in progress, and more decriminalization is taking place. But if you don't mind, three of you, I have a utilitarian view of, I am not a trained lawyer, but I, as an economist, as a business person, I have a utilitarian law view of the entire legal proceedings. I have one question which I'm drawing from some of the audience questions which were sent to us during the process of registration. And because in the interest of time, I'm just posing the same question to three of you. Going forward, Professor Thom Brooks, how do we see that, there is a possibility that, some of the corporate crimes may get decriminalized, but we are losing losing sight of the ultimate objective of the goal which an act of punishment is really seeking to serve. How do we balance it? That we of course you mentioned in your address type 1 and type 2 errors, wherein you end up punishing somebody who ought not to have been punished. How do you balance this going forward through your unified theory of punishments?
Well, if I'm allowed to speak first, I'll
Yes.
just say, and I know we have only a few minutes left. I want to first say massive thanks to the two brilliant presentations that have educated me enormously. and I really enjoyed it. And to answer this question, I sometimes joke to people that even though I wrote a book on punishment, I'm not actually for punishing anybody. In a sense, I'm very favorable to a more restorative approach. My issue is how some people think about, does restorative justice mean I'm restoring some metaphysical something or not, and patching up something that might not have been there. And I have issues with that, but I'm broadly more for a more restorative approach. And so I agree that that it's been good, I think, to see less criminalization after, in most jurisdictions, many years of the criminal law taking off and going too much, becoming too technical and not very often very badly applied. I think that's right. I agree with the comment that Judge Chaudhuri said about making a point about, is success getting more money out of fines rather than less? And the answer is, I agree. No, it isn't. Success is there not being problems. And if people are aware, look, if you don't change your tune, if you don't act appropriately, then the state will take a more heavy-handed approach with you. Okay, fine. I don't need to know this anymore. I need to get my procedures right. I need to desist from certain behavior. I need to get my house in order, and I'm now made aware I need to act appropriately. Then that sounds like success to me for companies, just as it would for individuals. That individual, likewise, we want to kind of stop behavior. We want to address people who've done wrongdoing, and if we and kind of doing kind of the full length of criminal justice is only really should be a last resort when other things are either unnecessary or not possible. So I think I agree with this move towards decriminalization broadly. I take and I don't think being heavy-handed is the best way of handling these matters. So I think that's all I'll say. I probably spoke twice as long as I should have.
Thank you, Thom. To both of you, I want to ask this question in other words that, as a company, I take a penalty as a cost, right? As a businessman, I take a penalty as a cost. So even if, let's say, I engage in a cartel or any other white criminal offense, there is a penalty waiting for me. I know that fully well, but I take it as a cost. So basically, the law is defeated once the business takes it as a cost and has absolutely no reason to be deterred. How do you guys, both of you are top-notch lawyers of this country, how do you see this phenomena, and how do you see a way forward that where correct course of action can be really induced? Manas, first to you.
Thank you, Navneet. The evolution of jurisprudence, if I go back to 1860, when our Indian Penal Code was enacted by the British India, it is still in absolutely fine to be implemented as on today. That shows that the persons who were writing the laws in 1860 knew that it should live up to at least 150 years. It has outlived even more than that. So the question is that in 1860, India enacted Indian Penal Code to define what is murder and how it is distinguishable from grievous hurt. In a grievous hurt, a person may be killed. It can be commuted to culpable homicide not amounting to murder. The question, to answer your question, I asked to myself, if in 1860 this was defined in the society as to how a person should be reprimanded for indulging into heinous crime, has the crime stopped in India? The answer is no. Because the individual culpability of the mind of a human being is historically subsisting for the last so many centuries. It doesn't end there. A company which you may say may have kept a kitty of X amount as a penalty for CCI and continues to indulge into that. As a lawyer who has just been into the competition practice for 20 years, I'm still learning that when I talk to the clients, they say, am I here to run an NGO? I am here to run profit. And if the market is not having any innovation, either by way of innovation which is measurable How do I run my business? Because there is a competitive force. That I am not putting any entry barriers to new entrant. I have to live within that oligopoly of 20, 30 people. And there is a demand in the market. How do I meet the demand? So when I sit down and try to introspect, I find that they have got some kind of a justification. I'm not saying that there are two kinds of cartel. One is benign cartel and one is absolutely no cartel. No, I'm not saying that. Cartel is cartel. Murder is murder. What I'm trying to say is that why in jurisprudence a murderer convicted by a trial court and confirmed in a high court still gets the commutation of life imprisonment at the Supreme Court. There I come to Professor Thom that every offense does not necessarily mean that there must be a deterrence to the extent that it is stopped forever. No, no court can guarantee that. There has to be a purposive interpretation of law, proportionality between crime and punishment. And in that regard, I think over the years, the jurisprudence in common law has evolved in that manner. When we apply those common law jurisprudence in economic legislation, we draw the persuasive value from there. It is not that no court, no authority, no agency would not be able to really reprimand the errors. They would. But for example, in 2020, when there was a cartel confirmation by the CCI, it did not impose any penalty. Why? Because the market situation due to COVID pandemic was so worse for economy, they thought that the cease and desist order is sufficient. It would not be making any headway if I just go and impose a penalty, causing more damage to the economy already shattered. So it all depends how you really case to case basis analysis. You may have seen the president of India did not allow the mercy to be a mercy. The last president had also given some of the mercy petitions confirming the death sentence. It depends. It is not that the provisions of the law or the constitution is not there. It is there. Only it has to depend upon case to case basis. One last thing, the amendment of the Competition Act is intended to have a fining guidelines because that has been our statement before the CCI for many years. And now the amendment has agreed to take that into the bill. And once that comprehensive penalty guidelines come into the law, I think the industry would be much more mature to understand what are the liabilities for breaching Competition Act.
That's a very, very useful observation. Thank you, Manas. Last word to you, Sujjain. How do you see this whole thing evolving?
So I think just like people vote with their feet, the markets vote for companies. And if you are going to look for capital, you will find that there are some companies who are darlings of the market, darlings of investors, and some who are not. So if you think you can get away by committing offenses and paying fine time and again, I don't think that is right. Because you will find that the capital that is flowing into companies today is a very mature and sophisticated capital. It is coming from mutual funds, it is coming from world banks, it is coming from large private equity players who have mandates, who have lots of things in their own charters, including the quality of a company's behavior with its stakeholders. And when they do that diligence, it is a very large part of their decision-making process as to whether or not they're putting money into a set of promoters and a company that will actually have the reputational issue, because these companies are then answerable to their investors as well in turn. So I think that sort of pressure is coming in, and now it has become almost a habit. You have to prove to every investor your ESG policy, your track record with fines, crimes, etc., your behavior with other stakeholders, your whistleblower policy. There are a number of mechanisms and tools available today to judge whether a company is actually one that is paying heed to the law, both in law and in letter and in spirit, as opposed to those who are willing to say, all right, I've got a product, so long as I make money, I'll consider this as a cost. I think that is no longer happening. You see a big divide between those who are really sought after and those who have fallen because of poor corporate governance and other issues. So I think it will be the market and the investors who will vote with their feet and companies won't get away by just breaching laws and saying this is a cost.
I think that's a extremely useful indication how responsible finance is emerging, and more financing institutions, banks, equity institutions, how they are seeking to induce discipline in the corporations. And that's a work in progress. A lot is being written internationally and nationally on that. That's a space to watch out for. But to conclude this session, it has been a great honor and true pleasure to hear three of you. It has been a very, very satisfying experience. Thank you very much for sparing your time, energy, and thoughts. You have enriched this session truly. Thank you very much, everybody. Have a pleasant evening.
Thank you. Thank you very much. Thanks.
Bye.
Bye bye.